Hello, this is attorney Jeremy Hogan and welcome to another edition of Legal Briefs, Crypto Edition. Today we get a little crazy American crypto style. Got a busy vlog today, so hang on to your hats. First, we are going to discuss the Tether lawsuit and then segue into what I see as the true danger to the crypto market and possibly the true savior. And then saving the best for last, we'll finish with the XRP lawsuit analysis, which was very interesting for me, and then a surprise at the very end to keep you hanging on. Quick disclaimer, I am a lawyer on YouTube with an American Psycho thumbnail. For all that is good in the world, do not take this as legal or financial advice. You are now crypto rich. Go spend your money on a local lawyer. The Lincoln needs new tires. Okay, let's get going. And I have been asked a lot of questions about the Tether lawsuit and spent some time yesterday to dig into it a little bit. If you are interested in crypto legal issues, I would urge you to sign up for a Pacer account, which is what lawyers have, which gives you access to the actual pleadings filed in all federal courts. It's a small charge. I think it costs about 3 cents a page to pull this stuff up. And also I would urge you to try to stay away from the media reports. Sometimes they just get it wrong and they're a little bit slanted in how they report it. So anyway, let's take a look at the June 2020 amended complaint in the Tether lawsuit. I pulled this up and I took a look at it. So let's take a look at it together. So here it is. And right away we see that it's filed in New York, which is probably a good venue for a complicated technical class action lawsuit. Now, I suggested in my last video to always go to the bottom of a lawsuit and look for what the damages are that the plaintiff is asking for, but that's not going to work here because it's a class action, meaning you're going to have a lot of plaintiffs and therefore no individual's damages are going to be asked for in the prayer for relief. But I do like how the plaintiffs throw it all on the table in paragraph 1. They tell us what the lawsuit is all about right out of the box. Plaintiff alleges that the defendants engaged in a sophisticated pump and dump scheme. Paragraph 2 alleges that defendants' misconduct was, quote, staggering in its scope and audacity. I'm not sure I like that paragraph as much, a little bit too dramatic for federal courts. Now, I want to caution you in reading any lawsuit that these are just allegations, and it's easy to allege things and make it sound horrible. For example, take a listen to this, and this is just something I made up, but to give you an idea what lawyers can do in pleadings. On December 31st, 2020, John Smith did conspire with his co-defendant, Jane Smith, to obtain and convey items regulated by the State Health Commission by utilizing a draft item governed by the Uniform Commercial Code and Interstate Commerce. Now, what does that mean if it was in a pleading? I just alleged that John and Jane ordered food for delivery and paid for it with a check. Point being, you have to learn to look beyond the strange legal language and get to the real issue to see what is actually being alleged and take away how horrible it sounds. So right away in this Tether lawsuit, I can cut through the fluff and tell you what the issue is here. And there's actually 2 of them. First, going down to paragraph 12, plaintiff alleges that defendants, quote, market manipulation caused the price of Bitcoin to increase 25 times. And by the way, Ether and Litecoin also spiked around that time. Now, that's a big allegation, and although I haven't had time to read the original lawsuit, I am guessing that the judge was not happy with this allegation in the original complaint. It was probably too bare bone in the original, and that's why the judge required there to be an amended lawsuit filed. Just an educated guess, because if we go down into paragraphs 260 to 290, let's look specifically at paragraph 272, we see the plaintiff trying to show the court how exactly Bitfinex pumped up the price of Bitcoin using Tether. And there's lots of well-done charts and graphs and diagrams. For example, in 272, the correlation is being made between the dollar transfer by Bitfinex, is that how you pronounce it? Which are the blue lines, and the green line, which is the price of Bitcoin. The plaintiffs in this lawsuit are in a difficult place because it's easy to allege a pump and dump, but it's much harder to prove it by facts and evidence that are admissible in a court of law. And this case will come down to a battle of experts, economics guys trying to argue really complicated market forces and pin them on the actions of one company. Now, the other issue I see right away will be damages. It's possible that certain plaintiffs bought at the allegedly inflated prices and sold at a loss. But it's also possible that some plaintiffs held on to some or all of their Bitcoin and are actually now up in their positions making money. I mean, Bitcoin recently topped its 2018 value, so it's very possible. And that would mean no damages for the long-term holders. In any case, the lawsuit certainly has teeth. There's some really bad stuff in there, but it's going to be difficult to meet the burden of evidence to prove that the defendants actually specifically caused the spike in price. Now, as the defendant says, quote, coincidence does not equal causation, and that is absolutely true. But there does come a point where even a circumstantial case can be proven, and there are some allegations in this complaint which would lead up to that point, and I think meet the burden if they are indeed proven. Now, I can't tell you what the ultimate resolution will be, but what I can guarantee you is that this is a case that will not be resolved quickly. But really what came to my mind finishing a review of the Tether lawsuit is a bigger picture issue because the allegations are really bad and they make for good sound bites. Fraud, RICO violations, collusion, and all of these things get to the ear of regulators and legislatures, and trust me, they are chomping at the bit to regulate and get a piece of the growing crypto market, the SEC, FinCEN, the Treasury Department. Which leads to my next quick topic, the coming regulation battle against crypto in general. Now, the SEC versus Ripple lawsuit is just the beginning. Crypto is getting too large to ignore and making too many headlines. Now, I did a fun video last Saturday, which only about 3 people watched, but that's okay, where I talked about money and how it has taken over the political process in the last 40 years. And this is an example of why it's really important to have a broad knowledge of the law and the things surrounding it, because it got me thinking, where are the crypto lobbyists and PACs? Look at this graph. It shows you some recent lobbying activities. See the U.S. Chamber of Commerce at $77 million and the Business Roundtable at $20 million? Now that money includes bank lobbies. Hell, even Amazon and Facebook spent $16 million each. So where are the crypto lobbyists? I mean, the battle has begun and crypto is not even on the field. I mean, Ripple spent like $200,000 last year on lobbying efforts. That's it. So I did find that there is a crypto association called the Blockchain Association, and all of you watching out there should get involved because this is where the war will be won or lost. Mark my words, I've seen it happen with workers' compensation in California in the 2000s. I saw it with insurance laws here in Florida in the 2010s. The insurance lobby got laws changed and won the war even when they were losing the battles in court. Point being, the crypto industry needs to get involved in lobbying and legislative efforts because that's where I think this is heading. Anyways, final topic for today and a surprise at the end. I want to talk about XRP and once again the Ripple litigation. I found something really game-changing for me this weekend. Now, a couple days ago, I was in bed, I was drifting to sleep, listening to a crypto YouTube channel. Does anyone else do that, fall asleep watching YouTube vlogs? And I heard the vlogger talking about an SEC lawsuit against Kik Interactive, except I was half asleep, so I didn't really, and I don't remember which channel it was on, and I heard KitKat for some reason, the KitKat coin, and then I fell asleep. So the next day I was at work searching for KitKat coin on my computer, but I couldn't find anything. But eventually I did find the Kik Interactive, K-I-K, Interactive lawsuit, and it involved the KIN token. And I eventually found the lawsuit and final judgment, and I pulled one very interesting little nuance from it that I had previously missed relating to the large amount of XRP held in escrow, a vital point. So let's start with the final judgment against Kik and take a look. This pleading is different than anything we've looked at before. This is a final judgment, meaning the case was litigated to a finish. This was not a settlement. Kik was sued by the SEC in 2019 for its ICO, and the allegations were that its sale of the KIN token was the sale of an unregistered security. Now, in the second paragraph, you see the procedural stance of the case. The court granted, quote, summary judgment for the SEC. Now, summary judgment means that the case was a complete slam dunk for the SEC. It means there was no issue of fact to even be looked at by the trial judge. It didn't even make it to the trial. I mean, the judge just looked at everything in the court file and made a determination that as a matter of law, the KIN tokens sold during the ICO were securities. And why is that important? Because in litigation, the winner drafts the final judgment, always. So I know that this final judgment was written by the SEC, and that's a little bit different than everything that's come before. So let's take a look at what it says. Now, skipping down to paragraph 3, it penalizes Kik $5 million, ouch, but Kik paid it, apparently. And actually, after this final judgment was entered, the KIN coin price actually spiked. I think it more than doubled, but that's not my focus today, that's for other people. Now, here's what caught my eye instead. Let's take a look at Roman numeral 2. It says that with respect to the tokens already issued and any new issuances of the tokens, the defendant must provide notice to the SEC 45 days before any sales. It doesn't say that Kik cannot sell the coins, just that it must give notice to the SEC. Now, I thought that was very interesting, so I went back up to section 1, and there I saw that the defendant was being enjoined from violating security laws in the absence of an exemption. Now, remember, the SEC could have drafted this any way they wanted, and they decided to allow for sale under exemptions. Interesting. So I went down that road a little further, and here's what I found. Now, going to the SEC website, I found the SEC Rule 501 Regulation D, and let's just take a quick look at that. This regulation allows for sale of unregistered securities to, quote, accredited investors. You just have to file something called a Form D with the SEC, and it's just something saying what is being sold and to whom, and then you can sell securities as long as they are to accredited investors. And here are what accredited investors are by definition. Basically, what you are seeing is that the SEC is supposed to protect the small investor where there is a large imbalance of power between the seller of securities and the buyer. However, if the buyer is a sophisticated investor or a company, they are considered an accredited investor, and you can sell securities to them by simply filing a Form D with the SEC. Now, I kind of knew about this before, I just didn't know that the SEC would allow it even after a successful litigation like in the Kik Interactive case. So, allow me to take off my lawyer hat for a minute and do some now semi-educated speculation. My last video ended with a question as to what would happen to the XRP in escrow if Ripple was not allowed to sell it. Now, some people said that the price would go up. I think that some of the more sophisticated responses were that the coin sales were needed in order for Ripple to continue its work on XRP coin usage cases and to finance operations, and that without the sales of XRP, even if the price spiked initially, it was not going to be beneficial for XRP prices in the long term because of the disastrous effects on Ripple. But now we have a new twist on this, because in the case where the SEC actually wrote the judgment against the company, its desired effect was to allow sales of the coins to other companies and large investors, only not to the regular old, Joe Smith on the street. Now, this solution, as applied in the SEC v. Ripple litigation, would allow the sale of XRP, but at a slower rate than previously planned by the escrow. Now, this solution would allow Ripple to continue its operations while still decreasing supply and thus increasing demand and probably the price. And that price action was exactly what we saw in the Kik Interactive litigation at the end after the final judgment was entered. The price went up drastically and stayed up as Kik sustained its business operations. Now listen, I understand that this is just one possibility out of 10, but the fact that the SEC's desired outcome leads to what I speculate would be a boon, not specifically maybe to Ripple, but to the holders of XRP, I see a setup for a win-win situation for XRP holders at the end of this litigation. And to end on a personal note, as I mentioned before, I had only owned Ethereum because I really was only very interested in smart contracts, and I really only took the time to understand Ethereum. But the last 2 weeks, I've learned more and more about XRP and prepping for these vlogs. I think I've done my due diligence now, and I understand what it makes possible, and it's very exciting, game-changing. And when I finished looking at all these things I went over today with you, well, I decided to jump into ownership of another crypto. Have a great day. Here we go.